Mesdames, Messieurs, chers invités distingués, on aimerait accueillir chaleureusement à cette discussion sur la réforme et renouvellement du Sénat du Canada. Welcome everyone to the discussion on the reform and the renewal of the Senate of Canada. This has been organized jointly by the Common Law section of the University of Ottawa and the Public Law Group of the University of Ottawa, in conjunction with several senators from the Senate of Canada. And for that reason, I'd like to introduce my co-organizer of this event, Senator Joyal. And I'd like to give a very brief introduction to Senator Joyal, and I'll let him also give you some welcome words. Senator Joyal is a jurist and a senator of Canada since 1997. He has a BA in law, a master's degree in law, and a graduate degree in comparative law. Between 1974 and 1984, he was a member of Parliament and a cabinet minister and Canadian Secretary of State. In 1980 to 1981, he was the co-chair of a special committee which studied and recommended the adoption of the Canadian Charter of Rights and Freedoms. And at risk of giving my age, I was there hearing the committee. Senator Joyal has long been recognized for his commitment to emerging rights and freedoms, and has had a great impact on society in general. He has appeared many times on his own initiative before the highest courts in Canada on legal issues touching fundamental rights, freedoms, and political institutions. He is also the author and editor of several articles and books on parliamentary and constitutional law. Senator Joyal, je vous donne la parole.
Thank you. Thank you, Professor Mendes. It's a pleasure and a privilege, in fact, this morning to be welcome at the Faculty of Law of Ottawa University, especially when I see my colleagues, sitting on the benches, and even welcoming Mr. Dion from the House of Commons. So I feel that there is, even in the House of Commons, I should say, the perception that there is a need to reflect upon the Canadian institution and fundamentally about the Senate, especially since the, I should say, turning point decision of the Supreme Court of Canada ruling in April of last year, 2014. As you know, that ruling of the Supreme Court of Canada is the result of a reference from the Canadian government and, of course, a unanimous decision of the Court of Appeal of Quebec on the same issues generally. And it appears to us that it was so fundamental as an interpretation of an essential part of Parliament, that is the Senate, that it would be welcome to pause and have a time of reflection, first of all, on the understanding of the ruling, what it meant, and second, what are the consequences that can be drawn from that ruling to envisage the next step. In other words, was that ruling the last word on any perception of the need to renew the institution of Parliament, because, as you know, the Senate is part of Parliament, and I think we should never envisage the renewal of the Senate without considering at the same time the impact it might have on the House of Commons. Because as the famous dictum says, it takes two to tango. Well, it takes two parts to renew the Parliament. And what you do in the Senate would have an impact on the House of Commons. That's why I welcome so much Mr. Dion. It speaks genuinely to his understanding of what is the reality of Parliament in the Canadian Constitution. So we thought that the first step would be to, as my friend Phyllis Lambert would say, to pick the brains of distinguished Canadian scholars, drawn essentially on their past reflection and past publication on the understanding of the Canadian Constitution. I know that Professor Mendes will have an opportunity to introduce each of them at length, but I think that in a first step, I thought it was important, and I share that interest with my colleagues in the Senate, be it in the Liberal Independent Caucus or on the government side or among the independent senators, that the first step would be to pause and to reflect upon the implication and the understanding of the ruling. The second step would be to take the results of that reflection and that exchange that we could have this morning with those guests, those distinguished guests, in the form that after their presentation, you will have, of course, an opportunity to ask questions, make comments, and have a general discussion with them. And on the basis of the conclusion of our sitting, we would publish a resume or a working document containing the essential points that we will have been hearing this morning, and we will broaden the consultation to the wider Canadian university community, to our colleagues in other parliaments, in the legislature, because provinces have an indirect impact on how the Senate behaves and performs, and of course in the political parties of Canada, so that we could come at a point in time with a kind of perception of what is possible within the constitutional framework of renewal without having to reopen the Constitution. Because I think that there is a perception among Canadians generally that to adapt the institution, you need to go through constitutional reform. Outside formal constitutional reform, there is no way for evolution. There's no room for evolution. Well, any one of you, of course, who has practiced Parliament knows that, I should say, some of the essential part of our political system works through the form of convention, and that convention can be changed with the consent of those who have to take the decisions. There's a lot of the working of the constitutional system that works through practices. There are elements of the system that are contained in the rules of the House of Commons and in the rules of the Senate. Each chamber can change those rules if there is a consensus base wide enough to do that. And there is also, of course, the Act of Parliament, like the Canada Parliament Act is a mere statute of the Parliament of Canada. Don't need the provinces to change that. So there are a lot of ways for our institutions to evolve without having to, I should say, imprison ourselves or our mind into the formal constitutional framework. And it is the objective of this morning session. It is, in fact, to see how the institution of government, of Parliament in Canada can evolve within the framework and the context that has been established by the Supreme Court in its famous ruling of last April. So that's essentially the object of our exercise this morning. And you will understand, and all my colleagues who are here, and I thank them to be in attendance, that it is so much important that there is, I should say, an exchange between the university community and Parliament. It is essential. If we really want to come forward with some, I should say, responsible proposal, it has to be because they will have been thought out with the contribution of those whose main profession and main job is to reflect and try to understand our institution of government. So I'm very indebted to Professor Mendes, that I will introduce with those opening words. Professor Mendes is a lawyer, of course, an author, a professor, and has been an advisor and consultant to corporation governments, including senior advisor in the Privy Council Office of Canada, civil society groups, the World Bank, and the United Nations. His teaching, research, and consulting interests include constitutional law, public and private sector governance, anti-corruption, corporate law, globalization, human rights, national security, and dispute resolution, and has authored or edited 11 texts in these areas. He has helped leading Canadian and international companies develop cutting-edge ethics and compliance systems. He has lectured in his areas of expertise across Canada, the U.S., Latin America, Europe, and Asia. He was recently elected as National Vice President of the International Commission of Jurists, Canadian section. Since 1979, Professor Mendes has taught at law faculties across the country, including the University of Alberta, the University of Western Ontario, McGill, the University of Ottawa from 1992 to the present. It's my pleasure, honorable senators and distinguished guests and distinguished member of Parliament, to welcome Professor Mendes and turn the meeting this morning to him. Thank you.
Thank you very much, Senator Joyal. I'm going to introduce the panelists one by one as they come up to speak. And the order that we've decided on is to go from the most general analysis of all the issues that Senator Joyal talked about to the most specific ones, dealing, for example, with appointment, the way in which the Senate can reform itself through its standing orders, its committees, etc., and then finally with a discussion by Professor Beaulac on some of the implications of the Senate ruling by the Supreme Court of Canada. So starting off with David Smith. David Smith is a member of the Order of Canada and is currently Distinguished Visiting Professor at Ryerson University and Professor Emeritus at the Johnson Schwayama Graduate School of Public Policy at the University of Regina. He has taught in the Department of Political Studies at the University of Saskatchewan and is a previous president of the Canadian Political Science Associations. He has numerous publications, including a trilogy of works on each part of Parliament, as well as books on political parties, the Constitution, and federalism. David, I give you the floor. You can either speak from the chair or come up here. It's up to your choice. Great.
Thank you very much. The title I gave my paper, although with me anyway, titles are not always accurate, The New Potential for Parliamentary Bicameralism. Except for the change in 1965 from appointment of senators for life to retirement at age 75, the Senate on the eve of Canada's 150th birthday continues essentially the same institution the Fathers of Confederation designed and approved. There is no mystery why Senate reform remains a subject for talk but no action. The answer is to be found not in what the Senate isn't, elected or equal, but in what it is, one part of Canada's most visible political institution. In other words, the core explanation for resistance to reform lies in bicameralism, a subject which, despite its prominence in the Constitution Act, is scarcely discussed in Canadian political science literature. Among the reasons for omission are the contagion of provincial unicameralism. Except for the Senate, Canadians have no knowledge and little memory of other second chambers, and secondly, the long-standing derision of the one second chamber that they actually have. Proposals for Senate reform usually begin with the premise that the upper chamber lacks legitimacy, a want of respectability which, according to this argument, may be remedied only from outside Parliament. Implicit is the proposition that the Senate should exist to fulfill a purpose, for instance, to represent the people or governments of the provinces. The indictment is narrowly cast, the argument aesthetic. Critics see the Senate through the prism of second chamber theory rather than as part of Canada's distinctive form of federalism. Never is there acknowledgement that the Senate is the only institution purposely designed by the Fathers of Confederation to serve the needs of the new Dominion of Canada. Comparisons are said to be invidious. I do not agree, and therefore will cite Patrick Boyer, a former member of Parliament and author of, most recently, Our Scandalous Senate, to illustrate my point. He writes that, quote, "The single greatest role of the Senate was this: enabling Confederation to take place at all. The day Confederation became a reality, the Senate's principal function had been fulfilled." For such interpreters, the Senate is weightless as an institution, its decades of history telescoped into one moment in time. On this last point, it is worth remembering that the Fathers of Confederation were intent on having, as the preamble of the Constitution says, a constitution similar in principle to that of the United Kingdom. Distrusting mechanical forms or abstract doctrines, the architects of Confederation, particularly those who had sat in the legislative bodies of the province of the United Canada, valued the accommodative capacity of parliamentary institutions. The same men had labored for a quarter of a century under the constraints imposed by the Act of Union of 1841. Experience disposed them to respect practice and precedent in the realm of politics. Thus, rather than demonstrating a theory, the Senate stands as a testament to what the framers of the Constitution thought Canada required to be a united country. More important still, and unlike critics today, they saw the Senate not in isolation, but in association with the House of Commons, for the reason that together each chamber served the needs of what may be described as Canada's double federation, 2 nations and ultimately 10 provinces. Parliament's upper house offered a platform for expressing concerns about the federation and minorities. Unlike members of Parliament, senators were not, in and of themselves, reflections or imitations of something else. They were not accountable to a constituency, however defined, or obliged to interpret legislation in any predetermined way. 2 consequences flowed from this feature. Bicameralism assumed fundamental, even existential importance. The 2 chambers must work, and they must work in tandem for the benefit of the Canadian people wherever they might live. At the same time, the second chamber must not rival the first. It must never, in other words, be elected by a constituency, since a democratic vote for the Senate would devalue everything else but that vote. If this were to happen, conflict between the chambers would follow, and the Senate's function as a moderating and unifying agent would be jeopardized. Senate thought would no longer be sober, that is, contemplative, nor would it logically come second. In their opposition to the upper chamber, Boyer, as well as some historians, Christopher Moore, for instance, personify, to my mind at least, an insular Ontario preference for majoritarianism. The difference between them and George Brown, who did favor a unicameral Ontario legislature, is that Brown realized the Federation demanded at the center what was not required in the parts, a bicameral parliament to help resolve regional tension. It may be an exaggeration, but it is not false to say that those who share this indictment of the upper chamber appear to be committed to the proposition that every man is, or should be, his own legislator. In consequence, the Senate as an institution is disparaged and its history disregarded. The physics of a unicameral parliament preoccupy their attention. For instance, according to Boyer, there are, quote, 2 solitudes of sovereign power, the crown and the people, even though this last solitude does not exist in Canada, where, unlike the United States, there is no theory of popular sovereignty embedded in the Constitution. Boyer employs the word people as a synonym for electoral democracy, a usage that again delegitimizes the Canadian model of bicameralism. To what extent, one wonders, is such malapropism attributable to the Canadian practice of claiming a constitution by association, be it found in the preamble of the Constitution or even earlier in Governor Simcoe's description of the Constitutional Act of 1791 as a perfect image and transcript of British government and Constitution. Why is it, one wonders, that Canadians never manage to be at the heart of their own story? The British analogy refuses to acknowledge the uniqueness and strength of the Canadian upper house. To begin with, its history is different from that of the House of Lords. No barons here. And in fact, the Canadian House of Commons and the Senate were, of course, created at the same time. Their history is coterminous. The test of the Senate lies in what it does, usually in concert with the Commons, and what it does in structure and practice is to validate Canada's distinctive form of federalism, a subject ignored by those who criticize the Senate on the grounds that it is undemocratic. More than that, this charge fails to acknowledge the primacy the Supreme Court of Canada has repeatedly awarded federalism. Quote, the dominant principle of Canadian constitutional law is federalism, the patriation reference. One of the Constitution's principles is federalism as a system of the country's government, the secession reference. And the Senate is a core component of the Canadian federal structure of government, the Senate reference. Bicameralism was as vital to the peace, order, and good government of the new country as the division of power was to preserving the Federation. Federalism was about more than resolving the conflicts of United Canada, although it is the case that political problems in that colony drove the Confederation initiative. The original Union comprised 3 colonies, then 4 provinces. Though few in number, those provinces were unequal, extremely so, in size and population. The Senate was designed to secure the voice of maritime and minority interests generally in a parliament whose lower house, based on rep by pop, overwhelmingly advanced the concerns of central Canada. Sherbrooke's Alexander Galt spoke especially for the provinces east of the Ottawa River when at the Quebec Conference he prophesied, "To the Legislative Council, all the provinces look for protection under the federal principle." Patronage and Senate appointments in particular, as well as appointment over election itself, are regularly cited to disparage the second chamber, as well as Macdonald's known preference for legislative over federal union. It is ironic, therefore, that Macdonald, the feigned federalist of this interpretation, should a century and a half later be celebrated as the preeminent nation builder of the world's most extensive federation. Then again, perhaps there is no irony. Perhaps Macdonald, a man who before and after 1867 regularly displayed a talent for vigorous political invention, perceived what theorists have not seen, that parliamentary institutions are extraordinarily adaptive. The object of criticism since its birth, the Senate of Canada, has never been described as impotent. Indeed, its potential for legislative influence is the factor that traditionally agitates the critics. The Senate's powers today are the same as they were at its creation. Indeed, every feature of the upper chamber, except for the term of appointment, is as it was then. It is imperative to be clear as to the Senate's fundamental features. First, as just noted, senators hold their positions until age 75. Second, there is a fixed number of senators, 24 per senatorial division, of which there are 4, plus 9 add-ons. 2 divisions are single provinces. The other divisions have 3 and 4 provinces, respectively. A consequence of this limitation is that the Senate, at 105 senators, is less than 1/3 the size of the House of Commons, almost intimate in atmosphere. Third, to repeat, the number is fixed, and it is extremely difficult to add extra senators, a feat done only once. And fourth and last, the senators are appointed on recommendation of the Prime Minister by the Governor General. Why did the Fathers of Confederation decide upon these particular features for the Senate, when in structure and operation the House of Commons was an imitation of the Commons at Westminster, while the Crown was assimilated totally into the new Constitution? Constitutional monarchy makes explicable, if not acceptable to some, appointment of senators by the Crown on advice of a Prime Minister. There's no need to rehearse the arguments against an appointed upper house. They are well known. What can be said is that constitutional monarchy offered a practicable method of selecting senators to the upper house at a time when there were few alternatives. Election was not popular in United Canada after the experiment of the 1850s. More than that, revitalization of the upper house through election relied upon a theory of a balanced constitution where each branch should be independent of the other, a theory largely destroyed by the rise of responsible government. At the same time, selection by provincial legislatures of delegates from among their numbers to sit at the center, as was done in 19th century United States, violated the common sense of Parliament as a supreme power, as in the United Kingdom, and the belief that British North Americans held that creation of a national parliament marked an important step to constitutional maturity. According to J.G. Bourneau, the only examples in the 19th century of unicameral polities were the republics of Central America, the Balkan states, and the landtags and diets of the Austrian and German empires. Membership in the upper chamber is by senatorial region. The guarantee of fixed, equal, regional, but not provincial representation with the more populous provinces of Ontario and Quebec was responsible for the entry of the maritime colonies. On no other condition would we have advanced a step, said George Brown. The Senate was a form of negotiated compensation for securing rep by pop in the House, compensation to Quebec for what it lost, equal representation in the Parliament of United Canada, compensation to the Maritimes for what areas of growth elsewhere would gain. In consequence of that agreement, it was possible to view British North America, at least when looking at Parliament's upper chamber, in the words of Christopher Duncan, minister in charge of the first census, as the three kingdoms. The allusion was to the United Kingdom, which encompassed England, Scotland, and Ireland, along with the Principality of Wales, and notwithstanding whose diversity appeared to the fathers of Confederation the paradigm of a successful nation. What was missing in the analogy, however, was federalism. Although Canada was a federal union, its politicians said amazingly little about this feature of the Constitution, except to haggle over the division of power. The Macdonald government had no vision because it had no theory as to how the Federation would expand, and thus was left to react to Riel's multiple demands when the rebellion took place at Red River. David Mills, Liberal journalist and later cabinet minister, charged the Conservatives with failing, quote, to do what the theory of their system required. A criticism borne out when introducing the Manitoba Act in 1870, the Prime Minister told the House that, quote, it was not of great importance whether the province was called a province or a territory. We have provinces of all sizes, shapes, and constitutions, so that there could not be anything detrimental in the use of that word. The failure to think through the imperative of federalism, how to expand the territory but not jeopardize the terms of the original agreement, has proved a major obstacle to achieving harmony in the Canadian political system. The disequilibrium caused by the acquisition of the West has never been righted, at least not in the eyes of the West. Although attempts to assure the maritime provinces that they would not be overwhelmed by the new provinces with large settler populations led in time to guarantees that made changes to the structure of the Senate almost impossible to achieve. Debate over what became the Constitution Act 1915, which among other objects created the Fourth Western Senatorial Division, prompted maritime disquiet at its prospects in Confederation compared to those of the booming West. A sample of that unease may be found in a passage of the Memorandum on Representation of the Maritime Provinces of 1914. Quote, each colony has a right to adequate representation. A self-governing colony is more than the number of its inhabitants, end quote. But the Constitution Act 1915 went further. No province, it said, was to have fewer members of the House of Commons than it had senators. And the Constitution Act 1982, Section 41, made that guarantee one of 4 specified matters requiring unanimous consent of all legislatures in the country for its amendment. Thus was created a Herculean obstacle to Senate reform, touching on the subject of membership numbers. Irish or French, depending how you look at it, playwright Samuel Beckett once exclaimed, "Ah, the old questions, the old answers, there's nothing like them." In the matter of the Senate, the clarity of the Supreme Court's recent opinion permits an escape from the quest, or endless quest of the grail of legitimacy, and opens the door to new thoughts on an old institution. Of course, the Senate of Canada remains preeminently a legislative body, whose authority derives from being one part of Parliament. Nonetheless, the precision of the opinion, preceded by the decision of the leader of the Liberal Party to sever senators from the Liberal caucus, presents an opportunity for the Senate to become more like the legislative institution Canadians keep saying they want. Less partisan, more open to the public, more collegial in the conduct of its business. At the same time, the opportunity exists to empower civil society, For unelected though it is, the Senate of Canada stands as an ally, not an opponent, of the popular will. The Senate of Canada is better situated than the House to connect with the public. With lower voter turnout generally, and especially among younger Canadians, the ballot has become the equivalent of a ticket of admission to formal political participation. Michael Adams has demonstrated very recently that political parties earn the least respect among political institutions, with only 7% of Canadians trusting them a lot, compared with 32% who don't trust them at all. There is nothing to stop the Senate of Canada from creating opportunities to listen to public opinion. In some respects, it is already well situated to do this. Canada is a country of contrasts, and one of the most noticeable is small and big size. Because the House of Commons is comprised of small constituencies and the Senate of a few large divisions, one would expect that the focus of the House of Commons business would be on the small and the Senate business on the big. But there is a counter-argument. First, there's a very big difference in the size of the two chambers, as I said, 105 versus 338 with the new redistribution, and in the contrasting trajectories of growth. In 1917, almost a century ago, the House of Commons had 235 members. This year, after the election, it will have 338. In other words, the House has increased in the last century by the size of the Senate. The Senate in that period expanded by 9 seats. Second, the House of Commons would be expected to represent smallness because of the multitude and variety of constituencies, but political party discipline annihilates localism. It always has. The smaller, more independent Senate is better positioned to articulate specific concerns, whether or not rooted in geography. Third, the House of Commons is highly polarized in an era when the public is more pluralistic and volatile in party affiliation. Again, according to Michael Adams, since 2012, quote, more than half of the population have been active in the past year, signing petitions, sharing political information online, and participating in demonstrations and protest marches. Political activity on the internet is growing rapidly, especially social media, and it is most popular among younger Canadians, those under the age of 30, who are more than twice as likely to use social media for political expression than those over the age of 60. A number of reasons may be offered for the development, but one relevant to the discussion is offered by Australian Judith Brett. Quote, people do not like the tone of parliamentary conflict and conduct. For those experienced with the modern informal meeting and its consensual style of reaching a decision, parliamentary procedure is no longer seen as enabling, but as precluding cooperative action. Adams says that half of Canadians, 50%, strongly agree with this following statement: political parties should allow MPs to vote in Parliament according to what they believe is right, even if this is not consistent with their party's position, while only 6% strongly disagree with that statement. The Senate of Canada has a reputation for being accessible and scrupulous in the conduct of its legislative work. Consider, for example, the examination of the Fair Elections Act. Embracing these qualities, the Senate acts as a bridge to the public, whose concerns most often are less political so much as they are aspects of concerns about the workplace, family, religion, health, diversity, citizenship. Like the country it serves, the Senate has demonstrated a capacity for adaptation and may still do so. Distinctively Canadian at its creation, it remains so 150 years later. Thank you.
Thank you very much, David. I should have mentioned that after we go through the panelists, we'll have a short break for about 5 minutes, and then after that, I'd like to get you presenting your views, your questions, etc. So start putting down your questions in case you forget what each speaker said. And there is coffee, too, at the very back of the room. And muffins, too. But not enough for everyone, so run and grab them before we go. The Hunger Games, or the Hunger Senate Games. Turning to Paul Thomas as the next speaker, he's a professor emeritus in political studies at the University of Manitoba, where he has taught for over 40 years, the last 10 as the first Duff Roblin Professor of Government. He has won both university-wide and national awards for his teaching in public administration and public policy. He has written several books and over 200 articles and book chapters. Amongst his publications are several chapters and research reports on the Senate. He has been a frequent consultant to governments in Canada and abroad on a wide range of issues relating to public management and public policy topics. In recognition of his various academic and other achievements, he has received many awards, including the Order of Manitoba in 2007. Paul, I'll give you the floor.
Thank you very much, Errol, and thank you also for inviting me to be part of this event. I was writing away a little paper I did for this, which is available to everybody if you'd like to contact me. Everyone's entitled to my opinion, I believe. So a friend calls up and says, let's go for a beer. And I said, I can't. I'm writing a paper on Senate reform. And he said, the Canadian Senate will be reformed when hell freezes over. To which I replied, well, I've spent several miserable winters in Ottawa, and it didn't happen then. And that's a bit ironic, coming from an academic from Winnipeg, a place where professors can both publish and perish. So the title of the paper is, Can We Design a More Effective and More Legitimate Senate Without Touching the Constitution? And rather than keep you in suspense, let me tell you what my premises are for these remarks. That the Senate is not nearly as useless and illegitimate an institution as its most strident critics suggest, and it's far from being a perfect institution. Second point, the Senate is first and foremost a political body, and therefore there will always be controversy about its role, its composition, its activities, and its overall performance in relation to other parts of the political system. The goal, therefore, should not be to design the perfect Senate. Instead, we need to think about how to make the Senate more effective and more legitimate. That is, to improve its functioning and improve its reputation with Canadians. There are undoubtedly significant constitutional and political limits on the types of reforms that can be introduced. But unlike the opinion of someone who matters, we are not stuck with the status quo. We can improve things. On the other hand, would-be reformers, and I'm among them, should be humble and cautious about making extravagant claims for their redesign proposals. I say this because there are very real limits on our understanding of how particular reforms to the Senate will interact with other changes taking place within the political system. Changing the Senate is not like calibrating dials on a machine. We don't know how to give the Senate just enough authority and just enough impact that it will become legitimate in the eyes of Canadian. And we don't know how those changes will complement and reinforce and support roles of other institutions like the political executive, the House of Commons, the federal system, the role of provincial governments, the courts, and so on. So no institution is ever completely effective or completely legitimate. The goal should be a better Senate, one that has more prospects of commanding credibility and respect. So those are my premises for where I begin. In the paper, which runs to 16 or 17 pages of densely set print, my friend said, that looks very dense, Paul. I said, well, everything I write is dense. But you mean it's really tightly typed? And he said, yeah, well, that too. So At the beginning of the paper, I talk a little bit, and I won't bore you too much with this, about clarifying the concepts of what we mean by an effective and legitimate Senate. By effectiveness, I mean the degree to which the institution fulfills the purposes for which it was established. And unfortunately, in the case of the Senate, it's established for a number of purposes, and we keep adding purposes or aims for reasons for having in a Senate. And the paper then goes on to identify 5 obstacles to achieving agreement on the effectiveness of the Senate. Like I say, over time, the purposes attached to the Senate have multiplied, and they're not necessarily complementary. At times, they can be contradictory. It's supposed to help congestion in the parliamentary process, be efficient and productive on one hand, but it's also supposed to be effective. So you have different types of expectations attached to it. Often, there can be legitimate debates over what types of constitutional or non-constitutional changes would be necessary or effective in bringing about a Senate that matters more within the policy and political processes. Given that we want to improve the Senate's role as a regional body, that we want to improve its role in the scrutiny and review of legislation, we want to improve its role in analyzing past policies and programs and promoting innovation and so on. So that's another complication. There's a question I think that we should come and discuss at some point over whether an effective Senate requires the hard power of a veto, which was the motto of the E.E. Senate reformers, or whether it can have sufficient influence on the basis of soft power of publicity and delay and debate. In a paper I did for the Ontario government back in 1992, when the idea of an elected Senate was under active consideration, I argued for a more modest set of powers for the Senate, not hard power or real power. And finally, in terms of the effectiveness of the Senate, it doesn't just depend on what constitutional authority it possesses. Many things happening within the political system, wider political system, will affect how much influence the Senate has. The dynamics of the party system, the existence of majority versus minority government, what's happening within the federal system, the aggressiveness or lack of aggressiveness on the part of provincial governments. The attitudes and orientation of the Prime Minister of the day is a key factor which will affect the influence of the Senate and effectiveness of the Senate. So the list, I think, could go on and on, hence the complications involved in making precise predictions. Let me say a brief word about the second concept which underpins the paper, and that's legitimacy. For purposes of the paper, legitimacy was defined as the public's perception, understanding, and acceptance of the validity of the rules of the political system, the roles of the various institutions that comprise the system, the procedures followed in reaching decisions, and the appropriateness and content of those decisions, in terms of those decisions being consistent with widely held, though not universally endorsed, values. And legitimacy is, in other words, I think, is a much more deeper and more complex phenomena than approval or disapproval registered in response to a single question in a public opinion survey administered by the pollster of your choice. And the second point I'd make about legitimacy is that it's often presumed in debates over the Senate that only an elected Senate can acquire legitimacy. However, the House of Commons is elected, and we've heard from David, and you can read the other surveys, that the House of Commons and its members, unfortunately, are not held in high esteem. There isn't a lot of trust and confidence in the House of Commons, and there are lots of reasons for that, and that I won't go into here. And the third point I'd make about legitimacy, that there are other appointed bodies which are part of our constitutional order, such as the Supreme Court and regulatory agencies, that enjoy much higher levels of credibility and legitimacy in the eyes of Canadians, presumably because of the basis on which they're appointed, the qualifications of their members, their relative independence from the political process, and the appearance, at least from the outside, that they engage in decision-making that's more evidence-based as opposed to based on pure, narrow political partisanship. So just in terms of applying these notions of legitimacy to the Senate, once again, there are a number of factors that will determine how legitimate the Senate is going forward. whether the public understands and accepts the role that it plays within a more balanced constitutional order, how effectively it performs and is perceived to perform its roles within the political system, how its members are selected and the social backgrounds they bring to their roles. The regional distribution, the regional makeup of the Senate will have an effect on its legitimacy, and the ability of the Senate to communicate about what it's doing and to reach the interested members of the public at least. And I want to come back to that towards the end of my remarks. The paper then turned to 4 avenues of reform. I'm not going to spend much time on a couple of those, only talk about them briefly. But the 4 avenues of reform were changes to the Constitution affecting the authority, role, and relationship of the Senate, including relationships with other parts of the political system, changes to the methods of selection and the types of people elected or appointed to serve in the Senate and the terms of their service. Thirdly, changes to leadership philosophy and operating style within the Prime Minister's office or within government more generally, and also leading to related changes to the institutional culture of the Senate itself. And finally, changes to the organization, structure, procedures of the Senate. Well, I thought for purposes of this morning, I would limit myself to talk just about a little bit about the selection process, say something about what I regard as the most important avenue of reform, namely cultural change within the Senate, and finally say something very briefly about structural and procedural reform. So a year ago tomorrow, I think it was, Mr. Trudeau announced that he'd expelled 32 senators from the National Liberal Caucus and announced that the Liberal Party would develop a new selection process that would eliminate the 2 central flaws of the current Senate appointment process, namely partisanship and patronage. I disagreed publicly with Mr. Trudeau with his actions to expel senators from caucus, but agreed that the search for a better appointment process would be a valuable initiative. As discussed in my paper, there is a dilemma involved with any appointment process. On the one hand, ideally it should be as transparent and credible as possible. On the other hand, the appointment process must not legally or unduly politically curb the freedom of the Prime Minister to place names of nominees for the Senate before the Governor General. The court rulings on Prime Minister Harper's reform plan determined that consultative elections at the provincial level would impair the freedom of the Prime Minister and change the balance within the constitutional order. Any new appointment procedure can and probably would be challenged in the court. However, if it were to become a recognized constitution, however, it has become, I think, here and abroad in the UK, it has become a recognized constitutional convention that prime ministers are free when selecting nominees to accept advice from whatever source they deem to be most appropriate. If a new appointment process is developed on an informal, non-statutory and non-binding basis, I believe that it would pass constitutional muster. But there are lawyers in the room and they have their opinion, so I will wait to hear that. In the paper, I discussed the Appointments Commission in the UK, which has, since its creation on a non-statutory basis in 2000, become a fixture in the UK constitutional order. All prime ministers in the UK, regardless of party, have declared publicly that they will only decline to recommend commission nominees in exceptional circumstances. Now, we have to be careful about drawing lessons from the UK, which has a quite different constitutional order, and as David said, the House of Lords is quite different from from Canada's Senate. We don't have hereditary peers here, for better or for worse, and so the number of appointments made by the Appointments Commission or recommended by the Appointments Commission is only a subset of the overall membership of the House of Lords. In Canada, an Appointments Commission, I don't think, should rule out the possibility of people with political pasts from serving in the Senate. The Senate is a political body. People will bring political knowledge, political skills to the role of legislating at the national level. In the UK Commission, one of its criteria is that you're supposed to have had no political past or political future that will impair your ability to act independently if you're one of the Appointment Commission's nominated lords. So So we need, I think, a more balanced membership in the Senate with people from different social backgrounds, some who are truly politically non-aligned, but we should not disqualify someone just because they have a political past. Let me turn then quickly to the second avenue of reform, which is trying to change the institutional culture of the Senate. Here, I think you start with the attitude and approach followed by the Prime Minister of Canada on any given day. That individual does a lot to set the tone and content of what goes on in the Senate. And I think that once the Prime Minister is accepting of a more independent, autonomous role for the Senate, a lot could change in a positive way. Many of the problems from the Senate's disgraced past, as critics would say, are not to blame so much on the Senate as the cavalier way in which governments have taken the Senate for granted or tried to push things through the Senate at the 11th hour. Both parties are guilty, I think, of that attitude. Cultural change, as you know, is a very slow, complex process, and it's uncertain. But I think we should begin to try and think about what sort of attitudes we want to predominate, what informal, unwritten rules of the game we want to have prevail within the Senate. Mr. Trudeau's aim, I think, was to try to eliminate partisanship not only in the appointment process, but also in the operations of the Senate. In my humble opinion, the elimination of partisanship within the Senate is neither desirable nor possible. I think the Senate, it will always have a partisan component to it. It's just how large and influential a role that partisanship plays. Senators, Mr. Trudeau seemed to believe that there's an inherent conflict between having a partisan background and serving as an effective spokesperson for a region. I know from past work on the Senate, several studies, that senators, particularly the more active contingent in Senate, take their representative regional role very seriously. They used to attend caucus. They used to speak up on behalf of their region. When the House of Commons caucus of the governing party lacked balanced regional representation, senators often substituted for MPs where there weren't MPs from a particular province or region. But because these activities as regional representatives took place usually behind the closed doors of cabinet or caucus, they went unnoticed, and therefore they were presumed not to be happening at all. So I think that partisanship is not in itself a bad thing necessarily. It's the way in which partisanship has been practiced in recent decades particularly. It's become too vitriolic, too much win at all costs, too much insistence that your political opponent has no useful ideas to offer to an informed debate on public policy issues. Trudeau also said that in his news release that this partisanship had impaired the role of the Senate as a chamber of sober second thought in terms of the review of legislation. And I think there again, we need more analysis and less commentary on that. We need to look at how the frequency of amendments. And two academics have recently done a longitudinal study of the Senate's amending, a tendency to amend legislation from 1988 to 2011. And it is a relatively small number of bills that come over from the House of Commons that are amended by the Senate. But the reasons for that go beyond the fact that people come out of a partisan background. Yes, there are controls and pressures and potential sanctions from the Prime Minister and the Prime Minister's office. But I think a lot of why senators vote along party lines are psychological bonds of shared thinking. If you spent a lifetime being socialized as a liberal, the day after Mr. Trudeau's announcement, you're not likely to stop thinking in a partisan manner. And I'm getting the hook here. I'll finish up quickly. I say a brief word then about structures and procedures. I think there's some interesting things happening, some interesting proposals being introduced to change the Senate rules and structures. I think some of the avenues that need to be explored is the developing a procedure for electing the Speaker of the Senate, giving the Senate Speaker more authority to balance majority and minority rights, give the Speaker the authority to split omnibus bills, create a more autonomous committee system through a procedure such as a selection committee to appoint and remove members, elections of chairs of committees, provisions for minority reports, requirements that governments respond to reports within a certain time period. And finally, an idea I've been promoting since the 90s is the Senate should have some sort of regional structure in its committee system, either in the form of a regional affairs committee with a large membership with subcommittees from the Atlantic, Quebec, Ontario, and the West perhaps, or all-party caucus committees of some kind. So I've identified 4 avenues of reform. I think a new appointment process and structural changes can be levers for institutional changes to the culture and so on. That will take time. The Senate has done a better job in recent years of putting more information about its activities up online. So you can get detailed information on an annual basis. It has a presence on the parliamentary internship site, which is quite useful. So I asked a random circle of friends from people I used to be involved with in the Cub Pack, we got together recently, how many people have ever looked at the Senate website? Eureka, no one had. One of the real problems is that whatever good publicity may come out of that, and I think it can be informative and educational, it gets crowded out by the bad news, and it just doesn't reach people. So in conclusion, as the old saying goes, we should not let the best be the enemy of the good. Let's work hard to improve the Senate. Let's not look for the best Senate. Thank you very much.
Thank you very much, Paul. I guess I'm the next speaker, so I don't need any further introduction, other than just to mention that on May the 22nd, we'll have a 5th annual conference on emerging issues in constitutional law, which my colleague Charisma Mathen is actually helping to organize, and feel free to find out more about it from Professor Mathen. Also, in terms of my other duties as the National Vice President of the International Commission of Jurists, Canadian section, we welcome the lawyers in this room to come and join. We're hoping to engage in many different projects, from reform of the methods of selecting judges to the balance between national security, human rights, and the rule of law. With that in mind, I'd like to focus on an issue which Paul brought up, and I am a lawyer, and so I'll address specifically the proposal to establish a nonpartisan appointments process for appointing of senators. But I want to start off with my analysis of the Supreme Court's decision in the reference re-Senate reform. And that one of the key messages that the court was giving to governments was that in any dealing or refashioning of institutional change, a very technical or literal reading of the Constitution will not suffice. The government must pay attention to what it called the architecture of the Constitution. Let me just quote directly from the decision. The Constitution should not be viewed as a mere collection of discrete textual provisions. It has an architecture, a basic structure. By extension, amendments to the Constitution are not confined to textual change. They include changes to the Constitution's architecture that modify the meaning of the constitutional text. When this decision came out, a lot of lawyers, myself included, constitutional lawyers, said, what on earth do they mean by the architecture of the Constitution? It was something new which had not appeared that frequently in the court's decisions. And my submission is that actually they had actually addressed this issue in the Quebec secession reference decision, where they focused on the foundational principles of the Constitution to determine the outcome in that case. And I suggest that the principles that they announced in that decision was referencing the architecture of the Constitution. So again, let me quote from the reference of the secession of Quebec. In order to endure over time, a constitution must contain a comprehensive set of rules and principles which are capable of providing an exhaustive legal framework for our system of government. Such principles and rules that emerge from an understanding of the Constitution's text itself include the historical context, previous judicial interpretations of constitutional meaning. In our view, there are 4 fundamental and organizing principles of the Constitution which are relevant to addressing the question before us. And the 4 that they mentioned were, firstly, federalism, something which my 2 colleagues have already been discussing, democracy, constitutionalism and the rule of law, and respect for minorities. And the reason why I think this quote reinforces the meaning of the architecture of the Constitution is that the reference with federalism and democracy really creates this tension which we now see in the discussions over how to reform the Senate, how to appoint senators, etc. Because while federalism, as both David and Paul have mentioned, is at the basis of the existence of the Senate, and which this country would not have existed if it had not been created, given everything else that David and Paul has said. At the same time, some have interpreted the reference to democracy as saying, well, you can get rid of it because we need only an elected upper house. I refer you to Senator Bellemare. Are you here? Senator Bellemare has actually done a really interesting discussion of this in the Senate itself, where she talks about how democracy actually includes an upper house which may be appointed, because it references to the issue of how do you represent minorities in the country as diverse as Canada. And I highly recommend referencing the speeches that Senator Bellemare has made in the Senate. So in my view, what the court has been basically referring to is that when you talk about reforms such as consultative elections or reducing the term of senators, you really have to focus on what is at the core of the architecture of the Constitution as regards the Senate. And the reason why they basically held that the consultative elections was unconstitutional and required the 750 formula was the following. And I want to quote from the decision of the court. Basically, they focused on the fact that the federal government, the Prime Minister, had said, well, nothing's going to change because I can still decide whether or not to appoint senators who have been elected by the consultative elections. The court actually zeroed on a contradiction there in the following words. We cannot assume the purpose of the bill is clear, to bring about a Senate with a popular mandate. We cannot assume that future prime ministers will defeat this purpose by ignoring the results of costly and hard-fought consultative elections. And here's the critical sentence. A legal analysis of the constitutional nature and effects of the proposed legislation cannot be presumed on the assumption that the legislation will fail to bring about the very changes it seeks to achieve. And then it goes on to say, it would modify the Senate's role within our constitutional structure, and here's the very critical phrase, part of the decision, as a complementary legislative body of sober second thought. They would weaken the Senate's role of sober second thought and would give it the democratic legitimacy to systemically block the House of Commons contrary to its constitutional design. So the focus, again, from the court's decision is that given the very nature of the Senate as a complementary legislative body, everything else must flow from that. They applied the same reasoning to the shortening of the tenure by basically saying, when you do that, you have to take into account what's the effect of shortening of the tenure on the, for example, the security of tenure and what that means for having the body as a complementary legislative body. So with that in mind, the question then became, if the shortening of the tenure, the consultative elections are unconstitutional without a formal constitutional amending process, and suddenly the abolition of the Senate would be well nigh impossible because the court clearly says that it requires unanimous consent. What else is possible? Well, here's where you have the suggestion by the leader of the Liberal Party that you could have a nonpartisan, independent appointment process. How would that be in accord with the Constitution? Now, as is well known, at least one political party, the New Democratic Party, has said, well, you've actually ignored another paragraph in the decision, paragraphs 64 and 65, which actually talks about the nature of the selection of the Senate. And I'm going to quote you, it's a very long paragraph, but I'm going to quote you the sentences they focus on when basically claiming that any nonpartisan appointment process would also be unconstitutional on the basis of the court's decision. And they focus in particular on these words. By employing the language of selection, the framers of the Constitution Act 1982 extended constitutional protection provided by the general amending procedure to the entire process by which senators are selected. So they're basically using that wording to say any form of selection process would also fall foul of the Constitution without a formal amending process. In my paper, which is going to be available, it will be published in the National Journal of Constitutional Law, I basically say that that paragraph has been taken out of context for this reason, that essentially the reason why the court focused on the method of selecting senators through consultative elections was unconstitutional because it would give democratic legitimacy and would systematically block the House of Commons contrary to its constitutional design. So it was taken out of context, and essentially it still opens the possibility of having a selection process that is not bringing a democratic popular legitimacy to the Senate, at the same time making sure that you keep the ability of the Prime Minister to take advice, and the crucial word is take advice on potential recommendations to the Governor General to appoint. And there are two templates which provide an avenue for actually establishing such a process. Firstly is the one we know quite well already, the appointment of Superior Court judges in Canada, which happens through a form of selection process firstly by advisory committees in each province and the territories, essentially receiving applications for the bench. Those advisory committees then do a formal screening process and make recommendations to the federal cabinet, and those recommendations then are decided on the basis of how the federal cabinet appoints judges. It has never been questioned whether or not that process is constitutionally suspect, and it provides an avenue for looking at a similar process for the Senate. And as my colleague Paul Thomas has alerted to, the template for that is the one in the mother of all parliaments, the British House of Commons, when in 1999, Tony Blair decided to introduce a system to actually help reduce the partisanship in the House of Lords, and the introduction of crossbench or nonpartisan members of the House of Lords to be recommended by a nonpartisan House of Lords appointment commission, which he established in 2000. Now, as Paul Thomas has suggested, I'm not suggesting that the House of Lords is in any way, shape, or form a clear template. Why? Because, as has been said, it contains hereditary peers, it has not got a fixed number, and there is partisanship which is actually encouraged in the House of Lords. And here, perhaps leave it to the question period, I think we have to make a distinction between adversarial party partisanship and partisanship in general. And I think the introduction of a nonpartisan process could, yes, allow partisanship, but take it away from the party political adversarial process, which is essentially making the Senate, not as effective as it could be. So if you take the House of Lords Appointment Commission as another template, what are the processes that we have to think about in establishing such a commission? Well, firstly, you have to be very, very careful about how you staff that commission. You have to have a set of national members, I'm suggesting 4, and then another set of standby members from each province and territory to basically come into the discussion whenever a vacant seat comes or a retirement comes from a specific region or territory. That national panel should be appointed by an open selection process with guidelines presented by the Prime Minister in discussion with all the party leaders and the provinces if necessary. But the open competition will determine who the Commission looks at. Ultimately, the Commission should be appointed by a clearly nonpartisan body, such as, for example, the Advisory Committee, which decides on the orders of Canada. If that is established, then the next stage of the discussion should focus on what are the criteria and what's the process. And again, it is not a clear template, but the House of Lords again presents some very interesting templates for us to consider if we decide to establish a national commission, such as the one I'm recommending. The criteria in the House of Lords basically focused on what Great Britain needs in terms of the House of Lords. What we need, and I basically list some of the criteria, and it brings out again some of the discussion that Paul Thomas has made out, David has made out, and Senator Bellemare, for example, has brought out in her discussion in this area, the need for reflecting the diversity of Canada in terms of language, region, gender, ethnic, and other types of minorities to make the Senate, if you like, reflect Canada's demography. It is absolutely critical in that respect, but it's also critical to think about criteria which brings into the Senate people who, actually I agree with Paul, again, they may have had political affiliations in the past, but who are determined to make the Senate, if you like, a reflection of something which, again, quoting Senator Bellemare, John Stuart Mill actually talked about in his support of an upper non-elected house, to bring, if you like, the diversity that the country has into the discussions on legislation and on the larger issues facing the country. And I know already there are great examples of that. Senator Kirby, for example, in his great work on healthcare, and others, Senator Munson, in terms of his discussion on autism, etc. We need a Senate which can bring in those big issues into the debate, ultimately so that it can present some of the challenges to the House of Commons to prepare the legislation. And finally, the actual way in which candidates could be screened could take into account not just the competence and the qualifications, but to make sure that there is an examination, as there is in the House of Lords, an examination of propriety in terms of whether or not any potential candidate could bring the reputation of the Senate into disrepute in the future. So the House of Lords has the ability to present a kind of template for us, but not completely, because it's very different nature. And I know that some senators, Senator Cowan and others, have looked at this, and I highly encourage this to continue and maybe discuss, continue a dialogue to see if we can bring that type of nonpartisan appointment process, which could still allow for partisanship, but not the party political adversarial positioning that we now see in the Senate. I'll leave it at that, and I will ask my next colleague. I don't get a clap? I'm shameless. My next panelist is Don Desserud, who is from, if I can find my, he's a professor of political science and a director of the faculty development at the University of P.E.I. He was former Dean of Arts at UPEI, and prior to coming to UPEI, he held several positions at the University of New Brunswick, including director of the Urban and Community Studies Institute. He's also been the Associate of Graduate Studies and chair of the Department of History and Politics. He has also published numerous articles on the Constitution, on Senate reform, on prorogation, and the Confidence Convention, and language rights in New Brunswick. Don, I give you the floor.
Thank you very much. So my interest in Senate reform stems back to 1990, which I'm shocked now to realize that was 25 years ago. In 1990, Premier John Buchanan of Nova Scotia was suddenly appointed to the Senate. He was a sitting premier at the time. Of course, he quickly resigned to take the seat. But this initiated some backlash and comment about how senators were appointed in the first place and what was appropriate. I found myself on an open line talk show on CBC trying to explain Senate appointments. And one of the callers identified himself as a retired coal miner, now living in Sussex, New Brunswick. He explained that he had worked very, very hard all his life, was now retired and had time on his hands, and thought he would make an excellent senator. He had been writing to Premier Lester Pearson to request such an appointment. In fact, had written several times, but to date, Pearson had not responded. So the fact that Pearson had been dead since 1972 didn't seem to occur to him. So I was reminded at the time of the story that is told about Arthur Meehan. And Arthur Meehan, upon entering the Senate, was also inundated with requests from worthy people asking to use his influence so they would obtain a Senate seat. And one such petitioner was a woman from Manitoba who explained that she had just finished marrying off both her daughters. and that this was a worthy feat all to itself. But she too had now time on her hands and would like a Senate appointment and hoped that he would use his influence to obtain one. And Meehan's response was very diplomatic, and he said that he admired her ambition because it was a very worthy goal for any Canadian to aspire to be in the Senate. And he left it at that. And I liked that because of the unapologetic nature of Meehan's response. His appointment was what it was. He accepted it, and he accepted the responsibilities that came with it. And that was the entry into my discussion paper that I wrote for this panel. And I came up with 5 recommendations. My paper, by the way, is very short. This is it. And we did not collude beforehand, by the way, but I find that many of my recommendations have already been made, which is quite gratifying to realize that I'm not way out to lunch. So I'll just go through them rather quickly. The first one has to do with this whole question of democratic legitimacy. We've already heard a bit about it. It's a concept that is bandied about very freely. There is no consensus on what that term means, but it's applied rather willy-nilly. In fact, it's used as a club, quite frankly, to beat against institutions that people don't happen to like. It has become a distraction. So what I'm suggesting in my recommendation number 1 is that the Senate would be wise to start to focus more on what it can do and on what it should do and not on what it should not do. And that does not need to apologize, nor do the senators need to apologize for their positions. The second recommendation may be a little more controversial, but I have been looking quite a bit at the whole history of the question of money bills and what they are and where they came from and where that expression comes from and how they fit into the Canadian Constitution. And my conclusion is that the Senate's power to amend money bills has diminished incrementally over time, but it has never been removed. And that although the House of Commons has claimed that the Senate must not amend money bills, the House of Commons does not have authority to tell the Senate what it can do on this area, and that it would behoove the Senate to reconsider its role and become more aggressive in its ability to amend money bills. Clearly, I think clearly, the Senate would not want to amend budget numbers upwards. I appreciate that point, but I don't think that its ability to amend money bills needs to be curtailed. And I think that even the effort in addressing this issue would be very useful. My third recommendation, similar to that, and again has been mentioned before in this panel, but I also believe that the Senate has the right, if it wishes, to divide omnibus bills. And the whole question of why omnibus bills are not to be divided is itself an interesting one. Has a lot to do with the fact that when you package together legislation as a government agenda, to then divide it can become an issue of confidence. You can imagine that if budgets were taken apart and the House of Commons approved pieces of it, but not other pieces of it, that a government would legitimately say that there was a want of confidence in their budget. And as a consequence, omnibus bills are often presented as confidence measures, but the Senate is not a confidence chamber, and it has its own speaker, and those were the rules from the prohibition from dividing omnibus bills ultimately comes from, and therefore I think it's something that they could do. And if you consider the distaste that we now see in the public for omnibus bills and the way in which governments are stacking legislation together that can't be parsed and is difficult to understand, I think this would go a long way. It has a long history, by the way, this prohibition, so it's not something that's recent with this. The problem has a long history, and it's not something that's recent with just this government. The next two I'm going to present with some chagrin. The name of my paper, by the way, is Some Immodest Proposals, because I'm uncomfortable with making these recommendations because I'm not quite sure that, as some of the other speakers have suggested, that we on the outside truly understand the workings of such things as the Senate, and therefore I'm afraid I'll get them wrong. But the first one is the whole question of what the rules that govern the Senate procedures are and how they can be reformed and changed. And that is obviously an area that the Senate has unilateral power. They can change their own rules. And one of the rules that I find really interesting, which I think the Senate should look at, is the rule that allows for the Senate to bring in this case, cabinet ministers to debate bills in the Senate chamber. And I find that interesting. I find the history of that rule very interesting, and I discuss it at the paper at great length. I won't go into details now, but it brings to mind the fact that the Senate does have control over its own proceedings, including at the structure and function of debate on the floor. So I'm not talking about people coming to testify before committees. I'm talking about them actually participating on the floor of the Senate. And the reason why I say this with some hesitation is that all the examples that I have where this has been tried have failed miserably. so I'm not really sure it would work, but it is something I think at least that it should be considered. One of the examples that I give, which is not quite the same but similar enough, took place in New Brunswick back after the 1987 election, which you will recall the Liberals won every single seat, all 58 seats in that election. And so measures were taken that would allow, in that case, leaders of the other parties that had no representation in the House to participate in debate, at least through committee of the whole. And they were invited to sit in the media chairs and to provide questions beforehand, which they could then would be answered by cabinet ministers, and then they would have a chance to then have follow-up questions. It didn't last very long. The experiment was a failure. None of the parties particularly liked it. It wasn't something that persisted. More recently in New Brunswick, after the 2010 election, when the Conservatives won, I was approached by the Premier to come up with a similar proposal to allow for representation by non-elected, for parties that did not have representation, as a way in which they could possibly participate in debate, as a way of opening up the procedures. And I did a report on that, but what I found when I met with all the party heads of the parties that were not elected, that they didn't want to do that. They all claimed that the right to participate in debate was something that you earned through an election. Of course, the Liberals in opposition at the time really didn't like the idea, but their argument was pretty interesting. They said that to do so would undermine their role as the official opposition. So those are all negative reasons why I'm suggesting what I just said might not work, but at least it shows you the scope and the ability of the Senate that has to do something of that sort. And if that's not the way, there are many other ways in which the proceedings could be made more open. And I don't just mean television, but more open in a participatory way. I'm just not sure what those are. And I'm hoping that the senators, if they're interested in that, would be able to figure something out. The fifth one is something similar in that respect. Most of my career in university has been in administration. As Errol said, I was formerly the Dean of Arts, and universities are constantly going through what we call rebranding exercises. And anyone of you have been in anything that approaches a rebranding exercise know that they are soul destroying. You have the sense that your mission is far too noble to be branded. But we have to face facts. One of the problems that the Senate faces is brand. And rebranding is something that is going to have to be done. And everything else that we're talking about is essentially a rebranding exercise. So maybe there are ways that without cheapening the process or destroying souls that the Senate can consider rebranding itself. One of the ways that I think would work very well is basically an extension of what it already does, which is its ability to hold public hearings, committee hearings across the country. I think that's an excellent way of getting the public to know more about what the Senate does. But I would suggest to you that despite the fact that excellent work is being done in this area, I don't think many of the public know what's going on or know much about it. So something of that sort I think, could be done far more extensively than it has. So those are the 5 proposals that I suggest in the paper. I make an overarching suggestion as well, that even if these don't work in themselves, there is reason to pursue them. The very act of thinking and pursuing these things, I think in itself, will go a long way towards restoring the public's confidence in the Senate. But the final proposal that I suggest is what I started with. The Senate does not need to apologize for itself, nor do the senators need to apologize for their positions. They are there because they're supposed to be there. That's what the Constitution says, and they don't need to explain any further. Thank you very much.
Thank you, Don. Actually, Don did have a paper which he said to me previously. And one of the issues he didn't discuss, which I thought was very interesting, is for the Senate to actually have a mandatory role in splitting up omnibus bills, which I'm sure is close to the heart of many senators in this room. La dernière conférencière est mon ami Stéphane Beaulac, qui est professeur titulaire à la faculté de droit à l'Université de Montréal. Il a débuté sa carrière à Dalhousie Law School. Il est docteur en droit international de l'Université de Cambridge. Sa formation est bilingue et bijuridique. Droit civil à l'Université d'Ottawa et common law à Dalhousie. Spécialiste des droits de la personne, il était clerc juridique à la Cour suprême du Canada. Il a séjourné en Europe comme professeur invité à plusieurs universités. Le professeur Beaulac a publié une douzaine de livres et 60 d'articles de doctrine. Il est fréquemment invité aussi comme expert constitutionnel dans les médias. Stéphane, je vous donne la parole.
Alors, bonjour et merci de l'invitation de vous adresser la parole. Comme Errol, juriste de formation, et évidemment, c'est la perspective que je donne sur les derniers développements en matière de réforme du Sénat, parce qu'on le sait, le 25 avril 2014, la Cour suprême du Canada rendait sa décision dans l'affaire du renvoi relatif à la réforme du Sénat. Le deuxième renvoi sur ces questions, en fait, puisque la Cour d'appel, dans une affaire parallèle, avait rendu une décision dans le même sens en octobre 2013. Dans l'avis sur le Sénat de 2014, rendu par la Cour, donc de façon on ne peut plus collégiale, les motifs débutent ainsi. Citation. Le Sénat est une des institutions politiques fondamentales du Canada. Il se situe au cœur des ententes ayant donné naissance à la Fédération canadienne. Fin de la citation. Je suis un professeur de droit et j'enseigne des matières de droit public, c'est-à-dire, même au Québec, du droit essentiellement jurisprudentiel. S'il y a une chose que j'aime montrer à mes étudiants et étudiantes de première année, c'est comment, dès la première phrase d'un jugement, on peut savoir, on peut identifier où ira la Cour. Ici, dans le renvoi de 2014, on remarque combien la Cour tient en haute estime le Sénat. Elle parle d'institutions politiques fondamentales du pays et elle ajoute dans sa deuxième phrase que le Sénat est au cœur de la naissance de la Fédération canadienne, rien de moins. On se doute bien qu'elle ne permettra pas que le gouvernement fédéral ait carte blanche, qu'il puisse unilatéralement le réformer et encore moins l'abolir. Bref, la Cour suprême du Canada, c'est bien connu dans le milieu, elle annonce ses couleurs, elle est pas très bonne pour garder le punch pour la fin. Le titre de ma présentation, comprendre le renvoi sur le Sénat de 2014 en termes de rule of law. Expression anglaise, rule of law, que je préfère à la traduction canadienne-française de primauté du droit ou traduction franco-française d'état de droit, parce que c'est le concept anglo-saxon de common law, le rule of law, dont il sera question. Maintenant, laissez-moi être candide, pourquoi examiner le renvoi de 2014 en termes de rule of law? Laissez-moi vous le dire immédiatement, parce que moi non plus, je ne suis pas bon pour garder le punch pour la fin. Essentiellement, c'est pour raccrocher, c'est ça l'idée derrière mon papier, c'est pour raccrocher le Sénat et la décision de la Cour suprême du Canada à un concept contemporain. La question demeure peut-être, pourquoi cet exercice? Parce que, à mon avis, la Cour, le message qu'elle envoie, que pour maintenir essentiellement la nature du Sénat, il faut que le processus de nomination, notamment, n'ait pas de légitimité démocratique, qu'on évacue l'aspect mandat populaire, autrement dit, parce que ce message, il est contre-intuitif. Il sonne faux dans les oreilles de bien du monde. Pas surprenant que les politiciens et politiciennes même suite au renvoi de 2014, qu'ils et elles ne veulent pas parler du Sénat, ils ne veulent pas y toucher, comme l'expression anglaise le dit, with a 10-foot barge pole. Ma thèse est la suivante. À défaut de pouvoir rationaliser le Sénat, y compris son rôle et le processus de nomination, à défaut de pouvoir le rationaliser suivant le principe démocratique, si important de nos jours pour des raisons évidentes, à défaut de ça, on peut comprendre le message de la Cour suprême du Canada dans son renvoi de 2014 en termes de rule of law. Un autre métaprincipe de notre ordre constitutionnel. Et la pertinence d'un tel exercice, vous me demanderez, c'est pour aider à réhabiliter, et là j'emprunterai l'expression de mon collègue, peut-être participer à un rebranding du Sénat sur la base des enseignements de la Cour suprême du Canada pour ainsi l'avoir raccroché à un des métaprincipes de notre ordre constitutionnel. Mon plan de match pour ma présentation, il est assez simple. Je vais mettre en évidence les passages de cette décision de 2014 qui sont utiles à ma thèse relativement au rule of law. Deuxièmement, je vais élaborer quelque peu sur ce concept, son importance au Canada et à l'international. Surtout, je le dis tout de suite, dans sa version substantielle, substantive rule of law. Et enfin, je vais montrer combien on peut rationaliser le Sénat à partir de l'avis de 2014 en ces termes, en termes de rule of law, en termes de ce concept qui pourra et devra guider les projets de réforme du Sénat du Canada. Cette conclusion, sachez-le immédiatement, elle est évidemment loin d'être complétée. C'est un working paper, après tout, et évidemment, je vais grandement bénéficier de vos questions, commentaires dans la partie discussion dans quelques moments, après la pause. Alors, commençons. Dans le renvoi de 2014, la Cour suprême du Canada, c'est ici que la technologie de l'information va m'aider, elle choisit d'aborder le cadre légal applicable à la réforme du Sénat en découpant les questions telles que soumises en quatre questions, à savoir, premièrement, les élections consultatives en vue de la nomination des sénateurs. Deuxièmement, la durée du mandat des sénateurs, qui devrait être à durée fixe. Troisièmement, les qualifications en matière de propriété. Et quatrièmement, la question de l'abolition du Sénat. Ce sont les deux premières questions qui m'intéressent parce que c'est là que la Cour et la Barre parlent de la nature et du rôle du Sénat. Et je vais donc me limiter à ces deux premières questions. Et pour être encore plus précis, je ne m'intéresse pas à la mécanique de la formule d'amendement, c'est-à-dire la procédure de modification de la partie 5 de la loi constitutionnelle de 1982. Je vais m'en tenir au principe, au message, beaucoup en lien avec l'aspect non démocratique. S'agissant de la première question, tout d'abord, relativement au processus de nomination et la proposition de tenir un vote consultatif. C'est surtout dans cette partie, en rapport avec la première question, que la Cour suprême discute, élabore davantage sur les différents rôles de la Chambre haute du Sénat, au nombre de 3, qu'elle avait identifié plus tôt dans sa partie introductive de ses motifs au paragraphe 15 et 16. Pour mémoire, ces 3 rôles, on en a parlé aujourd'hui, mais pour le faire dans la langue de Molière, au premier chef, le Sénat doit être un organe législatif complémentaire, chargé de porter un second regard attentif, traduction de Chamber of Sober Second Thought. C'est nul doute son rôle le plus important. Par ailleurs, la Cour suprême identifie un second rôle pour le Sénat d'assurer une forme de représentation des régions qui se sont jointes à la Confédération en 1867 et par la suite. Enfin, troisièmement, la Cour parle vraiment en tant que rôle du Sénat et sans être présent à l'origine, ce rôle est venu s'ajouter plus tard. C'est-à-dire que le Sénat est un lieu permettant d'avoir des parlementaires de divers groupes sous-représentés à la Chambre des communes. Historiquement, les femmes, ainsi, par ailleurs, que les groupes ethniques, religieux, linguistiques et autochtones. Pour revenir à la partie du renvoi de 2014 concernant la possibilité d'élection consultative des sénateurs, c'est là où se trouvent les éléments hautement intéressants en lien avec le rôle premier du Sénat. La Cour écrit ceci au paragraphe 57, et on peut suivre. Citation. Comme l'a écrit notre Cour dans le premier, renvoi de 1980, et on cite, « En créant le Sénat de la manière prévue par ce qui est devenu la loi constitutionnelle de 1867, il est évident qu'on voulait en faire un organisme tout à fait indépendant qui pourrait revoir avec impartialité les mesures adoptées par la Chambre des communes. » Et on ajoute dans le même sens, toujours au paragraphe 57, « Les rédacteurs ont cherché à soustraire le Sénat du processus électoral auquel participaient les députés de la Chambre des communes, d'écarter les sénateurs d'une arène politique partisane, toujours soumise aux impératifs des objectifs politiques. » Et au paragraphe suivant, autre citation, « Parallèlement, on ajoute, la décision de confier à l'exécutif la tâche de nommer ces sénateurs visait aussi à garantir que le Sénat deviendrait un organisme législatif, on en a parlé tantôt, complémentaire. Plutôt qu'un éternel rival de la Chambre des communes dans ce processus législatif, les sénateurs nommés n'auraient pas le mandat de représenter la population. » Fin des citations pour le moment. Ici, on voit clairement, à mon avis, dans les 3 passages, le point que je faisais un peu plus tôt, la description de la Cour suprême par rapport au Sénat, c'est, à mon avis, très contre-intuitif. En ce qui concerne la gouvernance interne d'un État de nos jours, c'est en porte-à-faux, rien de moins, avec le principe démocratique. À tout le moins dans sa compréhension première, compréhension étroite de légitimité, d'appui par vote populaire. Cela dit, je sais pertinemment qu'un certain nombre d'intervenants, dans ses écrits, le sénateur Serge Joyal et encore récemment, Madame la sénatrice Diane Bellemare, nous invitent à favoriser un concept plus large de la démocratie, en s'appuyant notamment sur les écrits de John Stuart Mill, sa double définition de la démocratie, soit le principe de la majorité numérique, soit, mais surtout d'autre part, le gouvernement de tout le peuple, la démocratie égalitaire. C'est un excellent argument, mais aujourd'hui, ce n'est pas le mien. Moi, ma thèse, c'est que les motifs de la Cour suprême, ça nous invite à raisonner en termes de rule of law. Et j'y arrive dans un moment. Avant ça, un autre passage concernant la deuxième question identifiée un peu plus tôt au sujet d'un mandat fixe pour les sénateurs. La Cour suprême, et encore là, dans ce passage, je commenterai les aspects pertinents, il nous dit, la Cour, nous avons déjà, paragraphe 79, nous avons déjà vu que les natures et rôles fondamentaux du Sénat sont ceux d'un corps législatif complémentaire qui donne aux mesures législatives un second regard attentif. Actuellement, la durée du mandat des sénateurs est directement liée à cette conception du Sénat. En effet, ces derniers sont nommés à toute fin utile pour la durée de leur vie professionnelle active. Cette inamovibilité vise à permettre aux sénateurs de prendre leurs décisions en toute indépendance lorsqu'ils procèdent à l'examen des projets de loi. Fin de citation. Encore une fois, à première vue, à tout le moins, ces propos semblent suggérer qu'afin, pour remplir son rôle, il faut que les sénateurs soient inamovibles et donc, essentiellement, qu'ils soient non élus démocratiquement. C'est un peu, c'est moi vous suggérer, dans le même sens que je disais un peu plus tôt, ça semble être difficile à avaler, être contre-intuitif, eu égard aux principes démocratiques. Et c'est ici, à mon avis, que doit intervenir l'autre principal méta-principe de notre ordre constitutionnel au Canada, à savoir le principe du rule of law. À l'international, y compris à l'ONU, le principe de la primauté du droit, l'équivalent de notre rule of law, c'est clairement dans l'air du temps, et ce, depuis un certain temps. Dans son rapport de 2004, devant le Conseil de sécurité de l'ONU, le secrétaire général Kofi Annan donnait la définition suivante, et je l'ai résumée ici. « L'État de droit, nous dit-il, désigne un principe de gouvernance en vertu duquel l'ensemble des individus, institutions, entités politiques, publiques et privées, y compris l'État, ont à répondre de l'observation des lois appliquées de façon identique pour tous et administrées de manière indépendante. Phrase suivante, il implique, ce principe de l'État de droit, d'autre part, des mesures propres à assurer le respect des principes de la primauté du droit, de l'égalité devant la loi, de la responsabilité au regard à la loi, de l'équité dans l'application de la loi, de la séparation des pouvoirs, participation à la prise de décision, de la sécurité juridique, du refus de l'arbitraire et de la transparence des procédures et des processus législatifs. Fin de la citation. Il y a, comme aimait dire mon collègue François Chevrette, maintenant décédé, il y a à boire et à manger dans cet extrait. Et en doctrine, pour aider à y voir clair concernant le concept de l'État de droit, on définit ce concept de deux façons. La version formelle, connue sous le nom en anglais de Formal Rule of Law, et la version substantielle ou réelle, qu'on pourrait dire aussi, en anglais Substantive Rule of Law. Et c'est cette dernière qui nous intéressera plus particulièrement. L'auteur américain Brian Tamanaha, assez récemment, aussi en 2004, a publié un livre faisant la synthèse historique du principe de la primauté du droit. Suivant la classification classique sur l'axe formel substantiel, il suggère de parler de thin version of the rule of law, allant vers le thick or thicker version of the rule of law. En français, on pourrait traduire, traduction libre, en parlant des versions minces et chargées du principe de la primauté du droit. L'idée de cette classification, et quand on suit la numérotation, c'est qu'à mesure qu'on progresse, les versions de l'État de droit, du rule of law, cumulent plus d'éléments. Par exemple, si on prend la formulation numéro 4 dans cette classification, elle inclut d'être régie par le droit, le principe de la légalité, le principe démocratique et enfin les droits individuels. Si on continue, en faisant cet exercice, la version numéro 5, quant à elle, inclurait les 4 premiers éléments, mais on ajouterait la dignité humaine et la justice représentative. S'appuyant, l'auteur Tamanaha, s'appuyant sur plusieurs références, surtout anglo-saxonnes, ce qu'il appelle « the British understanding of the rule of law », Brian Tamanaha, cet auteur américain, est d'avis que dans nos démocraties constitutionnelles, le principe de la primauté du droit se situe justement à la version numéro 4, peut-être même jusqu'à la version numéro 5, suivant cette classification, c'est-à-dire une version substantielle qui est par ailleurs assez chargée, en anglais « relatively thick ». Voici comment, c'était une de ses principales sources à l'auteur américain Tamanaha, voici comment le théoricien anglais T.R.S. Allen résume la situation. Citation, en anglais cette fois. The term rule of law seems to mean primarily a corpus of basic principles and values which together lend some stability and coherence to the legal order. The rule of law is an amalgam of standards, expectations, aspirations. It encompasses traditional ideas about individual liberty, natural justice, and more generally, ideas about the requirements of justice and fairness in the relations between the governed and the government. Nor can substantive and procedural fairness be easily distinguished, he says. Each is premised on respect for the dignity of the individual people. The idea of the rule of law is also, he says further, is also inextricably linked with certain basic institutional arrangements. The fundamental notion of equality, which lies close to the heart of our convictions about justice, fairness, demands, soulignement ici, demands an equal voice for all adult citizens in the legislative process. Fin de la citation. C'est le dernier bout, la partie soulignée, qui est particulièrement pertinente pour nos fins. Pour ce qui est de la réforme du Sénat, eu égard aux enseignements de la Cour suprême du Canada. Et je conclus ainsi. Sur cette réflexion qui est loin d'être complétée, je le disais tantôt, deux choses, 2 points, ou comme on aime le dire souvent en français, de 2 choses l'une. Premièrement, pour moi, le concept du rule of law, c'est la clé pour comprendre et donner un écho contemporain aux enseignements de la Cour suprême du Canada dans sa décision de 2014. Participerait éventuellement à un processus de rebranding de notre Chambre haute. Par exemple, dans les motifs de la Cour suprême du Canada, concernant la nomination des sénateurs, la première des 4 questions, la Cour insiste sur son rôle premier, on en parlait tantôt, à titre d'organe législatif complémentaire. On parle du processus législatif et de la sagesse requise et qui devrait être reflétée dans nos textes législatifs. Et au paragraphe 58, on y revient, autre citation, on cite, à vrai dire, la Cour cite un des pères de la Confédération, John A. Macdonald, qui, au moment des débats parlementaires sur la Confédération, disait ceci, citation, « Un Sénat dont les membres sont nommés aurait pour rôle de modérer et de considérer avec calme la législation de l'Assemblée et d'empêcher la maturité de toute loi intempestive ou pernicieuse, passée par cette dernière, la Chambre des communes essentiellement, sans jamais toutefois oser s'opposer aux vœux réfléchis et définis des populations. » Fin de la citation. Laissez-moi vous suggérer le lien direct entre ce passage et le concept du rule of law, dans sa version substantielle, dans sa version thick. À vrai dire, on pourrait paraphraser T.R.S. Allen, qui parlait d'une relation entre l'État et les sujets de droit, qui est empreinte de respect pour la dignité humaine, pour la justice représentative, ce qui requiert, ou à tout le moins bénéficie grandement, d'un processus législatif avec une chambre de second regard attentif. En anglais, Chamber of Sober Second Thought. Et c'est mon deuxième et dernier point, tout court, en conclusion, en plus d'aider à comprendre le renvoi de 2014 et de relativiser le principe démocratique, souvent omnubilant, le principe du rule of law constitue un genre de phare pour guider les propositions de réforme du Sénat, notamment en ce qui concerne le mode de sélection des sénateurs. En un mot, ça permet de concilier un processus de nomination des sénateurs non élus démocratiquement avec un méta-principe de notre ordre constitutionnel. La primauté du droit qui est, on le sait, prévue explicitement dans nos textes constitutionnels tels que confirmés par une jurisprudence unanime depuis le début de notre confédération. Mais aussi, ça donne un critère de référence pour réformer le processus de nomination, qu'il ne faut pas draper. La Cour suprême a été explicite à cet égard, qu'on ne peut pas draper dans le principe démocratique. Alors, à défaut de ce principe, on peut se rabattre sur l'idée de la primauté du droit, le rattacher à la version substantielle chargée, qui inclut les aspects relativement aux droits de la personne, à la dignité humaine et à la justice représentative. Alors, c'est tout. Merci de votre attention.